And our next presentation is on my favorite topic, motions to suppress or to terminate. And leading a team of 2 extern students working with him is the estimable Rex Chen. Rex has been a leading attorney at Catholic Charities in Newark for the last 9 years. He's one of those people who went to the other New York Law School, but we're still proud of him. And I'm going to let you introduce your colleague.
Hi, everyone. My name is Aggie Pappas. I'm a law student at Cardozo, and I'm interning at Catholic Charities for Rex, who is the managing attorney at Catholic Charities. I'm going to be co-presenting with Rex and Ishrat. Ishrat is a law student at Brooklyn Law School who is also interning with us. We're doing our presentation on motions to suppress and motions to terminate, the kids issue. And I would like to start off with a motivational quote from Yuri Kochiyama. Our ultimate objective in learning about anything is to try to create and develop a more just society. Okay, so there are 2 ways to go about winning a motion to suppress or a motion to terminate. With termination motions, you're basically throwing out the case because the government did something bad. They violated a policy or a regulation. And with suppression motions, you're trying to keep certain evidence out. As Professor Benson stated before, ICE has the burden of proof with establishing alienage. So the procedural framework is that with a termination motion, we're basically saying that the case should be thrown out because a regulation or policy has been violated. And it doesn't matter with termination motions, it doesn't matter if ICE proved the alienage. With suppression motions, the point is of excluding evidence to weaken ICE's ability to meet its burden. So with this one, if you decide to do a suppression motion, do not concede alienage, because that's what we're trying to suppress evidence so that ICE cannot prove alienage. And a lot of IJs don't know that ICE has the burden, so it's good to always inform them of that. Okay. And practical steps to winning a suppression motion. Always ask for an evidentiary hearing, but don't be shocked if the IJ improperly refuses to hold an evidentiary hearing. And if you decide not to challenge matter of Barcenas, then you're going to have to provide testimony and show a prima facie case. Okay. Also consider asking the IJ to rule that information on suppression cannot be used to establish alienage. And you could do this verbally through a motion in limine, which ICE counsel in Hartford, Connecticut concedes this. Okay, and also consider asking for a ruling that counsel can invoke the 5th Amendment on the client's behalf. And if ICE submits any evidence late, ask the IJ to terminate the case. Okay, some practical factors include if your client has a chance for relief from removal, then consider whether he would like you to proceed with a suppression motion or a termination motion. Okay, and some IJs really do not like, they really don't like suppression or termination motions, so find this out before you decide to move forward. Okay, I'm going to move on to termination for regulatory violations. So again, with termination, your claim is that the government violated a policy or a regulation, and that that regulation was intended to benefit your client. And again, you don't have to, even if even if ICE proves alienage, you could still win a termination case. Okay. So when you're trying to terminate a case because of a regulation violation, the BIA seems to think that that you actually have to prove prejudice, so that the violation causes your client prejudice. For example, if he was informed of his rights, then the proceeding would have gone a different way. The Second Circuit actually has a better rule and it's called the Cardi Doctrine. So if a regulation occurs, that a regulation of a policy or if a violation of a regulation occurs which safeguards an individual's interests, then most likely the case will be terminated. However, this was muddled by Raja versus Muskie, where the doctrine requiring proof for prejudice for violating pre-hearing regulatory violations. And then the Third Circuit rule is that is also a better rule than the BIA. If prejudice is presumed and the regulation affects a fundamental right that derived from the Constitution or a federal statute, the case will be terminated. Okay. And we're going to move on to regulations that specifically apply to children.